Then I will call the Rules Committee of the Superior Court to order. And the first thing I would ask is that Attorney Del Campo read the roll so we know who's in attendance from the committee.
Okay, Your Honor is here. Judge Armada?
Yes, present.
Okay. Judge Chaplin? Judge Green?
Here.
Judge Green is here. Judge Marsowski?
I think that's Maczarowski.
Maczarowski, excuse me. She was here. Okay. Judge McLaughlin?
Present.
Judge Pearson?
Present.
Judge Prats? Judge Stewart? Excuse me.
Sorry, Judge Prats is out on a personal matter.
And Judge Stewart?
All right, the first thing oh, go ahead.
You do have a quorum, Your Honor.
Thank you. The first thing I would ask is that only members of the committee right now have their cameras on. If we have participants who need to address the committee, then it would be appropriate at that time to engage your camera, but I'd like the members of the committee to actually be able to see each other as best we can do. So first, I want to welcome everybody back to the first meeting of the Rules Committee for this court year. We have some tried and true veterans, and we also have some new members, and we would like to welcome them to this committee. We have several items on the agenda. I think a lot of this is just going to be bringing us up to speed about where we are this month. We're probably not going to make inordinate progress this month, but I want to make sure that the new members of the committee are fully apprised of what has been left over from last year so that they can bring themselves up to speed. There are a couple of these proposals that are fairly far-reaching and have been a somewhat complicated history. So I want to make sure that everybody, especially the new members, have enough time to familiarize themselves with the issues that we are wrestling with this court year. So with that having been said, I would accept a motion to approve the minutes from the May 8th, 2023 meeting of the Rules Committee.
So moved.
Is there a second?
Second.
And I would recommend, well, you can do whatever you want, but if you are a new member of the committee and did not participate in the May meeting, you may want to abstain from this vote. But all in favor who were members of the committee, all in favor say aye.
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 Opposed say no. And anybody who is abstaining, please state your name so we can record that.
Mary Armada.
And Ernie Green.
Jennifer Maczarowski.
And anybody else? All right. I think that's it. Okay. Attorney Del Campo, you can obviously engage your camera as well. You are the ringmaster in many ways for these meetings. So the next item is 2021-023, a proposal to amend practice book section 7-10 and 7-11 regarding retention and destruction of summary process records. I know that this was a subject we discussed last year, and I believe there was some action in the legislature in the last session, Attorney Del Campo?
Yes, Your Honor. This first came to the committee in 2021. It went through the legislature in 2022 and did not pass. And it was vetted back and forth. Ultimately, the committee in May of 2022 was on the agenda, and it was tabled until September of this year, pending some legislation or pending review of what happened to the legislation that did not pass in 2022. Legislation ultimately did pass and is in your materials today. It's Public Act 23-207. It was presented back to the committee through the legal aid organizations. I know several attorneys from legal aid are here today to address that. At this point, You do not have any comments from Judge Bellis or from court operations on that legislation, but that is the newest item on your agenda. You had asked that it come back if and when legislation had passed. So I know Attorney Podolsky is here and several other people who may want to address you.
Okay, before we do that, just Attorney Del Campo, what is the, I don't have it in front of me, what's the effective date of the Public Act?
I believe it's July 2024.
Okay. All right. So with that having been said, and understanding that we're going to have to solicit input from both Judge Bellis and the Chief Court Administrator or Court Ops about implementation of this, I'm happy to have some brief comments from Attorney Podolsky. And did you say somebody else, Attorney Del Campo?
Yes, I believe several other attorneys from Legal Aid are here, but Attorney Podolsky, I think, can let us know that.
Okay, well, Attorney Shea is also available.
Oh, okay. Yes.
I don't want to prolong this. So who wants to take the lead and just frame this for the new members of the committee?
But I can do it. We haven't discussed among ourselves, so I'm happy to do something very brief. The legislature passed a provision of, as I said, effective next July, dealing in particular with summary process actions that do not result in a judgment in favor of the plaintiff landlord. That's to say withdrawals, dismissals, judgments for the tenants, that kind of situation, and essentially establishes a time period by which they should be removed from the public database. What we have suggested, to some extent, that's not the same as what was in front of this committee last year, but to a certain extent, it moots that. What the proposal to this committee was broader. However, what we have done is you'll see in your agenda there are two items that are referred to as new materials, and that basically is a suggestion that you should recommend. It's really a different amendment to section 7-10 and 7-11 to coordinate that section with the change which was adopted by the General Assembly, and so that's actually what the current request is, as distinct from the request from a year or more ago. I don't know if Attorney Shea is on this and Attorney Kelleher is here. I don't know if either of them want to add anything to that.
Briefly, do either of you need to add any additional context?
I think
All
that
right.
covers it. Thank you. Okay,
let me ask you, Rafi, have you or anybody started to engage with either core operations or Melissa Farley to start the coordination process?
No, I don't think that anything's really happened since the session. We had extensive conversations with judicial during the session, in fact, over the last really 2 years, but we have not had conversations since they passed the legislation. I'm assuming that the effective date of July 1st was at the request of the judicial branch, because the proposed bill would have had an earlier starting date. So I assume that was a courtesy to the department. The legislature gave them more time.
I am assuming that as well. For the benefit of the new members of the committee, I should say we work very closely with legal aid organizations, the Connecticut Bar Association, various affinity groups, depending on what the topic is. And we try as best we can to reach consensus whenever possible. It's a better outcome for the stakeholders, better outcome for the judicial branch. And so things don't always move as fast as some people would like, but having consensus is probably more important than speed in many instances. So for the benefit of the new members of the committee, what we would typically do, especially when we have something like this that has been around for a while but has taken some twists and turns, that we would refer this out to the various stakeholders to seek their input. It's normally in the context of written material that is submitted back to the committee for our consideration. Sometimes people will join us remotely to talk about any proposals as well. So in this instance, unless Attorney Del Campo has identified anybody else, I think we would refer this typically out to court operations for the logistical aspects of implementation, and to Judge Bellis as the chief administrative judge for civil to make sure that the proposed language is in keeping with operational needs. Is that right, Attorney Del Campo?
Yes, Your Honor. That's absolutely correct.
Do any of the members of the committee have any other suggested stakeholders who we might want to solicit input from, or do any members of the committee have any questions about this proposal at this juncture? Taking silence as acquiescence, then we will table this matter and solicit input. I'm sorry, Attorney Del Campo, when's our next meeting after this one?
It is on October 30th.
Okay. Maybe we could ask if both the Court Ops and Judge Bellis to get us their comments within a month, maybe by October 18th. That would give us time to review it between then and our next meeting.
Okay.
Does that sound good?
Yes.
Okay. If there's nothing.
I'm sorry, would you like us to attempt to make contact with those two in the interim?
Yeah, that's always probably a wise idea. It would probably, you don't need my permission to do that, but it might facilitate the process as well.
Okay, thank you.
All right. If there's nothing further on that item, we'll move on then to item 2022-020. It's a proposal to amend practice book section 17-51 to explicitly permit the entry of a summary judgment based on a defense that when that defense only affects part of a claim. Attorney Del Campo and or Judge Stewart, who's been quarterbacking this issue for some time.
As soon as I can get my microphone on. So I'm Judge Stewart, for those of you who don't know me. So yes, we had a task force that looked at this rule, and I should also mention section 1744, which is the first rule you see when you look at the summary judgment rules in the practice book. And I did read yesterday, I'll confess, the comments from some of our complex litigation docket judges. And as a result of that, I think the wisest course of action would be to table part of this, and that would be the 1751 part. I would suggest that the committee go ahead and take up the changes to 1744. And let me explain that briefly, and then I'll return to 1751 briefly. 1744, and for that matter, 1751, are the only sections of our practice book that use the terminology claim. Throughout the rest of our practice book, you typically see cause of action. And that is sort of a term of art based on our Supreme Court's case law. So our suggestion, and I believe where that came from, was essentially when the Rules Enabling Act came along and the federal rules of civil procedure were drafted, someone went and basically copied their terminology. But I think it would be wise to make 1744, regardless of what happens to 1751, consistent with our language on requests to revise, our motions to strike, etc., and to change the two places that it refers to claim to cause of action. So I would suggest that we try to address that now. With respect to 1751, there are a couple of reasons why I'm going to suggest tabling it. One is Judge Noble had some very thoughtful comments with which I concur about the request to revise and motion to strike portions of the practice book and trying to make things consistent. And honestly, I read this yesterday. I don't have time, nor do I think the people on the task force, to address that in less than 24 hours. So I think it would be wise if we step back and looked at all of that. Secondly, I do want some input from some of the commenters, including CTLA and including a couple of our judges, about what to do instead, let's just say, with respect to section 1751. I think we all would agree. Well, first of all, I hope everyone recognizes that right now, because some of the comments suggested to me people might not realize this, we've had on the books for decades a provision for partial summary judgment. It's not a very well drafted provision, but 1751 is that. That's not new. What we attempted to do was to make it clearer and better. The alternative is what Judge Farley suggests, which is to obliterate it. I have some issues with that because there is a lot of case law under the current 1751, and for us to just get rid of something might create more problems than it's worth. All that's a long-winded way of saying that I think it would be worth having some more discussion on 1751 before we bring it back, and possibly those other provisions in the practice book before we bring it back to you. But I would like for the committee to consider the one change to 1744. It's in two different places in the rule. It's not particularly complicated. It simply is replacing the language claim with cause of action.
Thank you for that, Judge Stewart. That makes sense to me, but I want to make sure that everybody has the input, but I want to make sure that the new members understand where we are with respect to 17-44. And if they have any hesitancy, we can, let me back up. We can take tentative votes now. It really just means that when we take a vote, we are approving a proposed change to go to a public hearing. And that hearing is in May, I believe. So, whether it's done this month or next month, it's not terribly important, but I do appreciate Judge Stewart's effort to help us clear out some items on our agenda. But if anybody has any hesitancy, it's not going to be a huge problem to hold off for a month, because there will only be one public hearing in May, and then we would have a final vote on all proposed rules in advance of the annual meeting of the judges in June. So having said that, do any of the members, particularly any of the new members, have any concerns with moving forward with 17-44 at this time?
Justice McDonald, this is Jennifer Macherowski. I don't have any concerns based on having what I read and what I've heard from Elizabeth. So
great. Okay. Then having said that, I would accept a motion, unless Attorney Del Campo, were you going to say something?
No, Your Honor.
Oh, okay. It's hard to read body language on this platform sometime. Having said that, then, is there a motion to approve the changes that are in the packet with respect to section 17-44?
So moved.
Is there a second?
A second.
It's been moved and seconded. Is there any discussion? Attorney Del Campo, I'm sorry, how many members of the committee do we have right now on that are in attendance?
Excuse me. 7, I believe, Your Honor.
Okay, so I can see. I just wanted to make sure I could see all 6 of the other members. So we'll do it this way. All in favor, please raise your hand. Opposed? That passes 7-0. Thank you very much, Judge Stewart. I appreciate all the work that you and Judge Farley and the task force have been undertaking on this matter. It's can be difficult sometimes. That's why I appreciate your work.
Right. Well, for those of you, Jimmy, just briefly say, those of you on the task force, I'll be reaching out to you.
Okay. Actually, for the benefit of the new members, Attorney Weiner, just disengage your camera until we get to your item, please.
Sure.
For the benefit of the new members, Judge Stewart, could you just state the members of the task force?
Yes, Judge Pearson, who's with us right now, and Eleanor Sterling of the CTLA, who I believe is on, but she doesn't have her camera on, and Jennifer Booker of the Connecticut Defense Lawyers Association.
Great. Okay. Thank you very much. The next item then is 2023-002, the proposal to amend MCLE Rule Section 2-27A to allow attorneys to earn up to 4 hours of MCLE credit by judging mock trials or moot court competitions. And now I would ask Attorney Weiner to engage his camera. Just for the Attorney Weiner, we have several new members of the committee, and I would ask you to just briefly share with members why this was carried over. We tabled it last year, and most importantly, tell us any new developments that have happened since we tabled it last year to the time it's back here on our agenda today.
I'm happy to, Justice McDonald, and good afternoon, Your Honors. Thank you for having me here today. Pleased to update you as to the status of this proposal. So as you can see from the report from the MCLE Commission attached as Tab D and the CBA's revised proposal attached as Tab F, the CBA has drafted numerous revisions to our existing proposal to amend the MCLE rule to allow an award of 4 hours of MCLE credit for Connecticut attorneys who judge or coach scholastic mock trial or moot court competitions. And that would be an expansion of our existing MCLE rule, which presently allows for an award of 4 hours of credit for judging law school or coaching law school moot court or mock trials. In an attempt to address the MCLE Commission's concerns that our original proposal didn't satisfy the content requirement of the MCLE rule, we made a few changes. The first change was to reduce the amount of credit available for non-law school mock trials from 4 hours to 2 hours. The second change was to clarify that credit could only be awarded for high school or undergraduate level mock trial competitions or moot courts. So that would exclude the middle school competitions from eligibility. We also made clear that the participating attorney must consider and apply substantive legal principles, including the rules of evidence, and provide a critique of the competitor's performance. And finally, we required sanction or sponsorship of the activity by a court, bar association, or ABA accredited law school. The intent there was to assure a degree of quality control over the program and the materials being used. It would also allow issuance of documentation to support the self-certification aspects of Connecticut's MCLE program. It's our view that these changes strengthen the initial proposal and address the initial concerns. But unfortunately, the MCLE Commission voted unanimously, with 3 members abstaining, not to support a proposed change to the MCLE rule, out of concerns that while they're worthy civics education endeavors, they don't necessarily demand the same intellectual rigor as do law school competitions. The CBA respectfully but vigorously disagrees with this assessment of the MCLE Commission as to the intellectual and practical benefits from judging high school or undergraduate moot court or mock trial competitions. We think that those competitions that are currently being conducted under the strictures of the new rules require attorneys and judges who participate to both consider and apply the rules of evidence and other legal principles, explain them to the participants, and really come away with far more professional development and practical skills development than you'd get from a mere civics education endeavor. That said, we recognize there's a degree of subjectivity here, and we believe that members of this rules committee would benefit from the opportunity to see or participate as a judge in one of these competitions before voting on this matter. So the high school schedule for this year is nearly final, and the CBA will be holding regional mock trial competitions this December in Bridgeport, Danbury, Hartford, Middletown, New Britain, and Waterbury, with statewide playoffs to follow in February. So I'm going to respectfully ask that we table this matter until a winter meeting of the Rules Committee in order to allow any interested member an opportunity to view or participate in the CBA's mock trial program in person before making a final decision on whether to send this for a public hearing.
Thank you very much. First of all, I should note for members of the committee that Attorney Weiner is the chair of the CBA's Civics Education Committee. In his professional life, I work with him pretty regularly. He's the permanent law clerk to the Chief Justice. And I know that Attorney Rowe is also with us. I'm happy to have her provide any additional commentary in her role with respect to the Minimum Continuing Legal Education Committee.
Thank you all. I don't disagree with the substance of what Attorney Weiner has told you. I think there's just a fundamental disagreement between the MCLE Commission and the CBA on it. They did want me to express, though, that they in no way are discrediting the value that doing moot court competitions provides both to the lawyers and to the students who are able to see them in their personal life. They just didn't believe that the rigor was there. So I think he's ably commented on it. And some of the CLE Commission members have in fact taken part in these competitions before. So they were not coming at it from a prejudice where they had not seen the work that was done.
Thank you. All right. With that having been said, I appreciate Attorney Wiener's suggestion that we table this until members of the committee who might be interested in seeing this from the perspective of what we're doing, but also to participate on the substance of the activities. So I would ask that Attorney Wiener, if you could make sure that you provide Attorney Del Campo with the information, written information about when those events are again and their locations, so that it can be disseminated to the members of the committee, and then we can take this up probably in what was the timeline? January or February?
I would say really any time after January. If you want to provide a full opportunity for the committee, we could probably even go to March, because we have rounds in December and February.
Well, our last meeting, Attorney Del Campo, right, is in March. Is that right? Before we have the public hearing in May? You're muted. You're muted.
Excuse me. Yeah, you're correct. The last meeting for new business is March, and then there's the public hearing in May.
So let's put this down for February, and then that'll give us enough opportunity. Okay.
That sounds good. So, I'll send Attorney Del Campo the schedule, and if any members of the committee would like to participate, you can register via External Affairs as well.
Thank you very much.
Thank you.
Thank you to both of you. All right, so the next item then is 2023-008, a proposal to amend various practice book sections regarding the pathways process in family matters. And right on cue, Judge Albus has joined us. It's always good to see you, Judge Albus. Why don't I don't know if you heard the beginning of this, but we do have several new members of the committee. And this has been a fairly long and circuitous route so far. So if you could try to frame it for the committee, particularly the new members. We're not going to be taking any action on it today because it is pretty complicated, but I want to make sure that they know that we're all on the same page.
Yes, and thank you, Mr. Chairman. I also will note in starting that Judge Leo Diana is in the meeting today. He's the new Chief Administrative Judge of the Family Division. My term has expired since this committee's last meeting, but I told Judge Diana.
I forgot about that. Good to see you, Judge Diana.
Judge Diana asked if I would be willing to come and sort of provide some continuity, and there is one matter that Mr. Chairman suggested at the last meeting that I do, that I have done, and I wanted to report on that. But the written materials that were submitted to this committee at the end of your last year for the new members, I don't have any written materials to add to that. They consist of a written summary of the pathways process that we've been using in family court since the mid-pandemic period. It includes the verbatim suggestions that were made by a working group of attorneys with whom we worked over a period of many months on suggested changes to our proposed rules. Our proposed rule changes, of course, are part of those materials. And then finally, there is a response by the branch through me to each of those suggestions, indicating which ones we had incorporated into our rules, which ones we had perhaps in a modified form taken heed of, and which suggestions we did not feel we could comply with. And there are some written communications from various elements of the bar as well. So you have all that. It's quite a bit to get through. I won't try to go through everything. Thankfully, I think at least some of the new members of the committee have worked in family court, so they they know what Pathways is all about. At the last meeting in May, it seemed to me, and I think others would agree, that the largest remaining issue that some members of the bar were concerned about had to do with the time frame and process for getting pendente lite motions, temporary motions for things like support or custody, alimony, heard under the Pathways process, with the elimination of the short calendar on which these motions used to automatically pop up. It was suggested that I reach out to all the family presiding judges to ask them their view of how things were going. And I did an informal survey of those judges, and some of the members of the committee are among the responders to that survey. And I'll just say generally, what the information I received shows is that the great majority of courts are doing the motion docket on a weekly basis, are granting the great majority of the requests to be placed on that docket, and that in most cases, those motions are placed on the docket within 2 to 4 weeks of the date of request. I also asked all the presiding judges to tell me of any complaints they had received, whether from attorneys or self-represented litigants, about the process, and particularly if there were specific motions that anyone had requested a hearing on where they complained that they didn't get a hearing fairly promptly. Of all the courts, only 3 courts responded to having received any complaints. And of those, there was only 1 specific complaint about a motion in a specific case not being scheduled timely. Some of the other complaints, and there were many, were self-represented litigants who felt that they should get a hearing sooner, but I didn't get any more details than that. Some people feeling, or at least one complainant feeling, that there wasn't enough time to hear the motion on the motion docket, which we know can happen. One sense I did get from reading the responses is that I do think we have to somehow redouble our efforts to inform self-represented litigants of the process for requesting a hearing. That seemed to be a common theme, that there's something more we should do to let the self-represented litigants know how they can go about requesting a hearing. Obviously, having a rule in place that sets out the process would be one thing that would help if the litigants look at the rules, but there may be more outreach that would be appropriate to do, and I'm certainly happy to talk to Judge Diana if he wants me to about things we might do along those lines. That was the general sense that I got from the presiding judges. And even though my term is over, if Judge Diana wishes me to help him in any way, I'm happy to do that as this goes forward.
Well, first of all, Judge Albus, thank you. I forgot, it slipped my mind that you had escaped the grasp of this problem earlier this year, and I appreciate you being here. Normally, people get their plaque at the July meeting and off they go, but you're very kind to spend some time with us today. Judge Diana, did you want to address this matter at this point?
No, I'm aware of what's been going on. Judge Albus has filled me in. I've reviewed all the material, and I'm gonna just keep following the clear path that he set to, address these issues and to make this program, work efficiently, not just for the attorneys, but for the self-represented individuals.
Okay. Are there any questions at this point for either Judge Diana or Judge Albus from members of the committee? Judge McLaughlin.
Good afternoon, everyone. It's very nice to see everyone after not being together for a while. I just had one question, and I'm not sitting on the family dockets any longer, but I saw that I believe that the legislature did pass amendments to 46B83 that require a pendente lite hearing be scheduled 60 days after it's filed. So I was just curious if that and this maybe is a general statement, if that alleviates some of the concerns that were originally brought forward by the bar, or if Judge Diana, Judge Albus, if that plays any role in your, if any, the continuation of pathways, sort of the rollout, or fine tuning, I'll say, of it. And that may not be for now. I was just focused on it due to my prior assignment, so I was just curious.
Yeah, I thank you for bringing that up. I had meant to mention that in my comments, so thank you. The Public Act was passed, as you described, and when the bill was proposed, as the Chief Administrative Judge, as I always was, and as Judge Diana will be going forward, there's a request from the branch as to a sense from the CAJ as to what their thoughts are. And the branch's position on that bill was that we didn't really object to it in concept. We didn't think it was necessary. And in fact, our belief then, and it's been reinforced by the results of my discussions with the presiding judges, is that hearings are happening quicker than 60 days, not just on the time-sensitive motions that are enumerated in the statute, but on other time-sensitive motions that aren't included. So I suppose, if anything, it tells us that what we're doing is within, and usually well within, the time frame the legislature thinks is appropriate. But we didn't solicit that statute. We didn't think it was needed, and we weren't really concerned if it passed, because that would be on the far end of the time we would expect in the normal course for a motion to come up. We did ask for some clarifications of some provisions of the original proposal. For example, my recollection is, as originally proposed, there would be no provision where a court could even continue a hearing that had been started, even if everyone agreed. And we thought that might not make sense, that there are times everyone agrees it's perhaps more efficient to push something off either to a later date or to the time of trial, if that is close. So I don't see that having a major impact. It's also a more cumbersome procedure to request a hearing under the statute. It requires an affidavit of certain facts being true, whereas under the motion dockets we have, you fill out a form that we've provided, you check a box and list your motion, and you ask that it go on the motion docket and maybe state in a sentence or two why it's important. So I think it may be more onerous, especially on self-represented individuals, to follow the procedure and the statute. And I guess it's good as a backstop, as a fail-safe, if for some reason someone weren't getting a hearing under the normal process in as timely a manner as they should. But from my perspective, it doesn't change a whole lot.
And I guess I would only add, I could just add, at least it just sets a timetable. So it does take one of the main issues, and now there's a square law on it. So although I believe, at least here in Hartford, we're the busiest jurisdiction, we've been able to do better than the 60 days based on what already exists. But at least now everyone knows what the timetable is. So I think it'll help.
Let me say I was not aware of the Public Act. Maybe Attorney Del Campo, you could lay your hands upon that and circulate it to members of the committee so that we can review it. We, as I said at the beginning, we try to work collaboratively with stakeholders, and certainly try to work collaboratively with the legislature. I just wondering, we don't need to discuss it now, whether there was any discussion in the legislature about the legislature legislating in the context of procedural rules for the branch. It's a little odd. I can understand their policy concern, but typically the internal procedural matters of the judicial branch are for this committee and for the judges of the Superior Court. So we can maybe talk about that offline, but the statute is where it is, and I'd like to see a copy of it. If there's nothing, do any members of the committee at this point have any questions for either Judge Diana or Judge Albus? All right, so let's put this on again for next month. And hopefully everybody will have had an opportunity to, frankly, I need to dust off some of my recollection about some of this as well, which is maybe I'm the only one, but I need a little more time. So let's put this on again for next month, okay? Judge Stewart.
I just have a suggestion for when we address this next time. My understanding from each of the discussions we've had about these is that there's a package of rules, some of which don't even have really are not that relevant to pathways, but they all have to do with family practice. But I understand that it's only 25-34 and 25-50 that have drawn fire, so to speak, and that the other rules, and I specifically remember Attorney McNamara from the family bar specifically stating to us that the other rules are not controversial. So I'm suggesting possibly when we address these next time that we at least take the package of rules that there's no issue about and address those and perhaps pass them. And then there is, I do believe, 25-34 and 25-50 warrant us paying some special attention to, if nothing else, just on the drafting of them and so on. But I think those other rules, we're making it a little more daunting than I think it needs to be by having the whole package there. And I think we could at least take care of the ones that have no controversy, and then spend the time that's necessary on the other two.
That's a very helpful suggestion. Do either Judge Diana or Judge Albus have take any position on that? Maybe clear out some of the underbrush so we can focus more clearly on what remains to be addressed. Does that make sense?
Sense to me.
Sense
Okay.
to me too.
Okay. All right. We will try to do that. Thank you very much, Judge Stewart, for that suggestion. Next then is item 2023-012, a proposal to change the Judicial District of Fairfield to the Judicial District of Bridgeport to bring it in alignment with the the Judicial District of Litchfield to the Judicial District of Litchfield at Torrington to bring it in alignment with recently enacted public acts. Attorney Del Campo, do you have any other additional information, or Attorney Petrozelli?
I don't think I don't, Your Honor. I think this is just exactly what Attorney Petrozelli has said. Sometimes we find these things because year end, we have to go through the different charts and reference tables in the practice book, and we find these things. Attorney Petrozelli usually brings these things forth when she's policing the practice book. So we have a couple of these. The next item is very similar. So it is just at this point a housekeeping measure.
Okay, and for members of the committee who haven't met Attorney Petrozelli, she's engaged her camera. She works with Attorney Del Campo and does a tremendous amount of work for this committee and doesn't nearly get the accolades that she deserves for that work. It's sometimes very tedious work. She does national surveys for us, and it's very, very helpful information. So I want to make sure everybody had an opportunity to put a face together with a name. So Attorney Petrozelli, thank you. If there's nothing from members of the committee, then we can actually move something forward, I think, on that item. And so I would accept a motion to approve the proposed change in 2023-012.
So moved.
It's been moved. Is there a second?
Second.
It's been moved and seconded. Is there any discussion? Seeing no discussion, all in favor, please raise your hand. Opposed? That passes unanimously. Then item 2023-013, again, is a housekeeping matter. I shouldn't say that, but to bring our practice book language in conformity with public acts, proposal to amend practice book section 2-13A to add a reference to the United States Space Force. Is there any further information we need on that, Attorney Del Campo? It is what it is.
Yes, Your Honor. It is what it is.
All right. Is there a motion to approve?
So moved.
It's been moved by Judge Chaplin and seconded by Judge Armada. Is there any discussion? Seeing no discussion, all in favor, please raise your hand. Any opposition? That passes unanimously. Next is item 2023-014, informational memorandum related to Public Act 23-16 and AI technology generally. Attorney Del Campo, do you want to frame this? Well, let me just say, we have heard a lot about the use of artificial intelligence in various contexts of late. And several judges have expressed a concern that we should probably try to be in front of this issue if we aren't already behind it. And so this is really just to start launching a discussion so that we can start thinking about whether or when or in what manner we want to consider rules relating to AI. I've seen some news articles where attorneys used AI in briefing that got them into trouble. So this is nothing other than launching a discussion. But Attorney Del Campo, would you like to say anything further?
Well, I think this came about, I had flagged it for legal services to try to determine whether or not there would be any impact on the practice book. Justice McDonald then had asked simultaneously for us to look at this just to prod the discussion at the committee level. And you'll see in here, there doesn't seem to be an immediate impact on the rules that we have in the practice book, but there's just some suggestion that you may want to be proactive in terms of heading things off and not allowing certain things. My immediate concern was that there were practice book rules that perhaps had to change or were impacted. It doesn't seem that way. But I think that based on Justice McDonald's request, we provided the information about this particular public act, and it's a jumping off point, I think, for your discussion, as Justice McDonald indicated.
So after I had spoken to Attorney Del Campo, the Chief Justice also raised this issue with me and was wondering if we had launched into this great new world. Typically, the law is probably about 10 years behind technology, so we're trying to potentially cut that time frame down. There are, I don't have it handy, but there are a couple of members of the CBA who are co-chairing a committee. I forget what the name of the committee is, that's trying to address some of the artificial intelligence issues. So I think what I'd like to do, and we can certainly discuss it, but I think what I'd like to do is see if there is any member of the committee who has a particular interest or expertise in this area who might want to start pulling together a working group to discuss this. I don't know that this is something we necessarily need to do as a whole committee at this point until a lot more investigation and tilling of the soil is done so that we can figure out what other states are doing. I don't believe there's much been done by other branches, other judicial branches. It is popping up in case law, and Attorney Del Campo and his team have provided us with a fair amount of material that I will confess I have not reviewed in any detail at this juncture. Is there, well, let me back up. Is this an area that people think we should continue to look into or just drop it and see what happens? Attorney Stewart looks like she's going to weigh in.
Well, I have just a general question. I'm not sure what exactly we would be creating rules for. I mean, I'm certain that law firms that are practicing in front of us are already using AI in electronic discovery, for example, and maybe are using it for legal research. Hopefully they're doing a better job than the guy in the Avianca case. But, I'm just curious as to whether anyone has any notion of what rules we would enact to regulate that. I don't know that there's anything wrong with that. that would
Well,
require any rules.
I certainly don't know the outer parameters of this topic. I'm not qualified to really opine on it. I could envision something. It could be very elaborate. It might be something as little as saying in a certification on your brief that if you've used AI in any form, that you've independently verified the authenticity and accuracy of the information. It's your own work product. You're not pawning off AI as you have a professional obligation to do a lot of research and document it and make a representation to the court that it's accurate. It might be just as simple as that.
So I guess
It'd be a lot more complex. Go ahead,
if I may,
Jeff.
I would just say I think that the simpler we approach this, the better, rather than having some long, drawn out, elaborate definition that presents itself in a way that can create loopholes more so than trying to not allow them. So I think the shorter version would be preferred if we do anything. Because I guess the question is, do our current rules not already address this in a way that would be sufficient for our purposes?
I don't know. Again, this was really just a effort to make sure that we're at least thinking about it. We may do nothing, but if we choose to do nothing, it should be an informed decision, not for lack of diligence.
Well, can we at least find out whether anyone's doing anything with respect to the federal rules of civil procedure? They probably have more resources at that level to address some of these things.
That's a good point, Judge Armada.
If picking up your theme about collaboration, if there is a CBA committee or task force looking at it, do we invite them to write to us and say if they think that there needs to be changes? I mean, I have seen in popular legal literature about certifications and trainings and things like that. Maybe they'll take a look at it and say, we should have a rule that says this, and look at what the federal system did or some other state did, and something for us to consider.
I agree. And unfortunately, I got an email from Justice Keller on this subject with the information from the people from the Connecticut Bar Association. And I just can't multitask right now to find it. But there is somebody working on it from the CBA. And Judge Armada, you have great connections at the CBA. Maybe you can find out.
Well, I will find that out. I also know the Connecticut Bar Foundation is doing the Kravitz Symposium on AI and its effect on litigation. And they've pulled together a great group of speakers. I know Justice Katz was involved in that, Ernie Maddie. I can reach out to them and see and report back.
And I appreciate that. And I had also, just so people know, I forwarded that information about the Connecticut Bar Foundation to Attorney Del Campo. He's trying to figure out if we can get somebody from his staff to attend that symposium to find out if there's any useful information for us to consider. Attorney Del Campo.
Yes, Your Honors. The committee that they have, I guess, is called the CBA Privacy and Cybersecurity Committee. I think the co-chairs are Attorney Castricone and Triffin. I'll send you that email if it hasn't gotten to you yet. Those, I think, are the co-chairs of the. So we do have that information.
Is it Dina Castricone?
Yes.
I know her. I can reach out to her too. But I know that while the CBA is doing one track, the CBF is also doing another track. So maybe we can pick from both and see if there's anything that they can think of. I'm happy to take that on.
I think we have a new task force chairman and Judge Mott. Judge Green, were you trying to say something? I thought I saw your hand going up.
No. I agree that we need to. I'm not sure I understand the great peril of AI, but I think that we need to get in front of it just to make sure that we understand everything that's going on, just to make sure that we don't miss anything. So right. Certainly, I'd like to get involved.
There could be great benefits too.
Agreed.
Like drones. They're good uses and they're bad uses of drones.
That's right. They're tools. It's a tool.
Okay. So maybe Judge Armada, you can reach out to those folks and just start scratching at this issue?
Yes, sir.
All right. So I think, is there any other business for us to do today, Attorney Del Campo?
No, Your Honor. That concludes your day.
All right. Judge Armada, did you want to say something? Okay. Then I would accept a motion to adjourn.
So moved.
And is there a second?
Second.
Second. All in favor, please raise your hand. Opposed? That passes unanimously. I thank you, and I take it as a victory that we were able to do this within an hour. So thanks very much, everybody, and have a great afternoon.
Take care, everyone.
Thank you.